Welcome to Bioenvironmental Sciences 367, United States Environmental Regulations. Dr. Heather Wilkinson is your instructor. An Introduction to Law. This slideshow provides an overview of the concepts in Chapter 1. During this chapter, students will recognize branches of government prescribed by the Constitution, including the fourth branch, review the cycle by which policy is established, including the roles each branch of government plays in establishing environmental laws and regulations, identify the records maintained by the federal government in order to keep track of the law and rulemaking processes, for example, the Code of Federal Regulations, the Federal Register, the U.S. Code. Follow the path of a bill through the legislature. Explain how lobbying takes place throughout the process of a bill becoming a statute. Compare different classifications of law. Recognize the constitutional principles involved in interpreting environmental statutes and regulations. Relate general legal concepts and principles in Chapter 1 to environmental law and regulations specifically. The American legal system, the source of environmental law. In order to understand how citizens and policymakers have responded and can respond to environmental threats, we must first understand the U.S. legal system. This includes laws, litigation, conflict resolution, and administrative law. The United States government creates laws based on powers delineated in the Constitution. The original Constitution had 7 articles. The first 3 articles described the preparation of powers among the legislative, Article 1, executive, Article 2, and judicial branches, Article 3. In addition, Article 1 also prescribes that Congress will delegate the implementation of laws, which allows for administrative agencies, frequently referred to as the fourth branch of government. Where to find environmental laws? Inasmuch as any of the 3 branches of government can create a law that impacts the environment and several administrative agencies implement regulations to govern actions under laws, it is important to recognize that the documentation for different laws and regulations will be associated with where each branch records their work products. This is why it's helpful to know the history of origin for a given law or regulation. As we learn more about rulemaking in this course, you will see it is important to understand the distinctions between the U.S. Code, the Federal Register, and the Code of Federal Regulations. The U.S. Code is the official compilation and codification of the general and permanent federal statutes of the United States. It contains 52 titles. The main edition is published every 6 years by the Office of Law Revision Council of the House of Representatives, and cumulative supplements are published annually. The Federal Register is the official journal of the federal government of the United States that contains government agency rules, proposed rules, and public notices. It is published daily except on federal holidays. The final rules promulgated by a federal agency and published in the Federal Register are ultimately reorganized by topic or subject matter and codified into the Code of Federal Regulations, the CFR, which is updated annually. The CFR has 50 titles, most of which roughly correspond to administrative agencies. For example, OSHA regulations are Title 29, the labor title, and EPA regulations are Title 40 CFR. The legislative branch as a source of statutory law. Article 1 of the U.S. Constitution defines the legislative branch as including Congress with 2 houses, the Senate and the House of Representatives. Legislative powers are those pertaining to the creation of statutes, The two-body nature of the legislative branch was quite purposeful on the part of the Founding Fathers. The Senate is widely considered to be both a more deliberative and more prestigious body than the House of Representatives due to the longer terms in the Senate, the smaller size, and the statewide constituencies, which historically led to a more collegial and less partisan atmosphere. How a bill becomes a law. A law starts as a bill, but its life is precarious. At any point in the lawmaking process, support may wither or it may be rejected outright and get swept under the rug or start over. A bill is proposed by a congressperson and may be drafted by lobbyists representing an interested party. The bill author may include personal interest or hidden writers or pork barrels in the draft all additions meant to further their own political agendas. Then the draft is introduced into the proposing congressperson's chamber of Congress, the House or the Senate. The bill may be referred to the appropriate committee. In each chamber there are standing committees by topic, for example, agriculture in the House, but agriculture, nutrition, and forestry in the Senate, and special committees, House rules, and joint committees between the chambers. These committees hear testimony about the subject matter of the bill. Lobbyists may testify in these hearings. After hearings and testimonies within the committees, a bill goes through a markup and subcommittee vote. A markup involves summaries, defenses, and problems of the bill. If voted forward in the subcommittee and the committee, it is voted on by the whole chamber. From there, a conference is held between chambers during which many revisions may be made and there will be a revote. During this reconciliation stage, the president might make public remarks to indicate his support or rejection of particular aspects under consideration. Eventually, there can be a whole congressional vote to forward the bill to the president, who can approve it as a statute. If the president rejects it, for which he has many options, 2/3 of the Congress may still override that rejection. Final statutes go into the U.S. Code, USC. As you may be able to tell, this process is laborious and can take years, if it even follows through to completion. If the bill passes and becomes a statute, it is codified and recorded in the U.S. Code and the U.S. Code annotated. The legislative process is intentionally slow, but this can help and hurt effectiveness of policymaking. Progress in the legislative process is reported in the Congressional Quarterly Weekly. This record is useful for keeping interested parties informed and also for subsequent investigations of legislative intent during court challenges. People with interest in the language of the statute or with interest in whether or not a bill becomes a law will lobby the congressperson directly. For example, set up a meeting with the representative or senator or provide campaign contributions. Alternatively, individual citizens might organize and build a campaign to engage their representative about the issue. For example, a letter or email writing campaign or a rally outside the Capitol building. This is considered grassroots lobbying. Historically, organizations representing environmental interests have had far less financial capacity to make campaign contributions or to buy ads to influence public opinion. Your book shows an example during the 2008 presidential elections where the environmental groups were outspent 25-1 versus the energy sector. After the 2010 Supreme Court decision in the case of Citizens United versus Federal Election Commissions, wherein the limits on contributions by corporations and unions toward advertisements during elections were lifted, now individuals and grassroots movements may face an even greater disparity in the influence should they find themselves on the other side of an issue important to a wealthy corporation. This table from the textbook lists organizations that engaged in environmental lobbying. There are organizations that represent business and organizations that represent public interest in the environment. Although most congressional lobbyists, especially those working on behalf of the business interests, are paid professionals, a large number of lobbyists fighting for public interest in the environmental legislation are extremely committed volunteers. Article 3 of the U.S. Constitution defines the judicial branch of government, made up of federal and state courts. The primary function of the judicial branch is to interpret the U.S. Constitution and statutes. This interpretation occurs through the court system, and it serves to both settle disputes and define the details of laws that are vague. Aspects of laws may have been left vague during the legislative process in order to ensure passage, or with societal change, the law may be vague due to changes in the conditions under which it was applied. Courts may use the congressional record to determine the intent of the legislature during the passage of the laws. Where no law or constitutional basis exists, the courts create case law, sometimes called common law, through court decisions. All cases are reported in court reporters, providing documentation for precedent within that jurisdiction. When precedent is set by a higher court, then lower courts rely on that decision to guide their own decisions. The concept of stare decisis is the basis of precedent. Stare decisis means let the decision stand. Judicial review is the power to decide whether a law follows the guidelines set by the Constitution. This power was created by a landmark case, Marbury v. Madison. The results from the cases are published in various reports. The Supreme Court decisions are found in the U.S. reports, which is particularly relevant for environmental law. Article 2 of the U.S. Constitution describes the powers of the executive branch. This branch is composed of the President, the Vice President, the Cabinet, which is a group of advisory representatives from 15 executive departments. The President's Cabinet includes the Vice President of the United States, secretaries that head the Departments of State, Treasury, Defense, Justice, Interior, Agriculture, Commerce, Labor, Health and Human Services, Housing and Urban Development, Transportation, Energy, Education, Veterans Affairs, Homeland Security. Also included in the Cabinet are the White House Chief of Staff, the leaders of the Bureau of Alcohol, Tobacco, and Firearms, the Central Intelligence Agency, the Environmental Protection Agency, the Office of Management and Budget, the Council of Economic Advisors, the Small Business Administration, as well as the United States Trade Representative and the United States Ambassador to the United Nations. The executive branch is involved in environmental law by influences it has on the legislature and administrative agencies, and by some forms of direct rulemaking unique to this branch. While not directly responsible for creating statutes, the President and members of the executive branch are influential in passage of laws via public support for the legislation or by indicating likeliness to veto a given version. The President can call attention to any issue by calling a press conference or holding an event, which is then covered by the press. This relatively unique power to focus the press and therefore focus public attention on any issue is referred to as the bully pulpit. No single congressperson, not even the leaders, can consistently get this sort of attention. Further, The Office of Management and Budget is among the departments represented in the Cabinet. OMB is responsible for cost-benefit analysis associated with evaluation of administrative regulations. The President proposes the budget while the Congress approves it. The President also suggests a legislative agenda each year during the State of the Union address. In many cases, the President appoints the lead administrator at government agencies. Direct rule-making associated with executive branch includes executive orders, signing statements, and treaties. Executive orders are a presidential directive authored with the advice and consent of associated agency as appropriate. This form of direct rulemaking is one way a president can directly and immediately implement change or create a law or rule where none exists. While many executive orders may simply remain the law of the land, an executive order of one president can supersede or rescind the executive order of another. Immediately after the enactment of an executive order, it is published in the Federal Register. Executive orders are codified in Title III of the Code of Federal Regulations. The bar graph shows the history of executive orders expressed as the number of executive orders issued per day in office. Signing statements are a way of diluting or changing statutes instead of imposing a veto outright. There are three types of signing statements. The constitutional type asserts that the law is constitutionally defective in order to guide executive agencies in limiting its implementation. The political type defines vague terms in the law to guide executive agencies in its implementation as written. And the rhetorical type uses the signing of the bill to mobilize political constituencies. In recent times, the use of signing statements has been controversial. George W. Bush used signing statements more times than all presidents combined, and his use of them was condemned by the American Bar Association. Treaties are a specific lawmaking power of the president. Treaties entered into by the president are subject to the advice and consent of the Senate. Once ratified by Congress, the treaty becomes the law of the land. It is a federal law, so based on the supremacy clause, no state can pass a law that supersedes it. Treaties associated with the environment are particularly important because they have international influence. U.S. participation is significant because we have such a large economy. Our actions shape the behaviors of business. An excellent example of where the U.S. served as a leader is when President Reagan entered the Montreal Protocol in 1987. This treaty mandated reductions in chlorofluorocarbons and halons in an attempt to stop ozone depletion. Administrative agencies. Article 1 of the Constitution gives Congress the authority to delegate rulemaking authority to the administrative agencies. Specifically, Congress delegates authority to make rules governing the conduct of business and labor in certain areas based on public interest, convenience, and necessity. One important concern associated with administrative agencies having these powers is that there are no elected representatives involved. Thus, the rules that affect the people are at least one step removed from a representative government. However, the rulemaking processes include established periods of public comment and participation. Proposed and final rules are published in the Federal Register, and the public has the opportunity to comment on the proposals. We will discuss administrative agencies and agency law in depth during our study of Chapter 3. In the United States, laws are created based on powers defined in the Constitution. The legislative, executive, and judicial branches all act to provide checks and balances on each other. The administrative agencies are considered the fourth branch of government, and they have powers that mirror many found in the other three branches. All branches report progress they make toward new laws or regulations regularly. Further, once a law is established, it is codified. In this way, all branches can be responsible for understanding the current state of law. Classifications of law. Case and statutory law. Laws are classified into either case or statutory law, depending on how they are made. Case or common law is established by the court. This is law made by judges as cases are decided and precedents are set. Statutory law refers to a law created by the legislature. Statutes can be procedural and describe a process, regulate and restrict agency or public and private actions, enable and empower agencies to enforce laws, or they can be amendments written to modify established laws, including the Constitution. Public and private law. Public law is meant to benefit general welfare and is often applied by administrative agencies. It regulates groups, organizations, or classes of people. Environmental law, labor law, antitrust law, and securities law are all examples of public law. Private law is set up to regulate conduct between two individual parties. Examples of private law include tort, personal injury cases, breach of contract, and nuisance law, criminal law, and civil law. Criminal law is meant to punish and deter certain actions. Violations of criminal law can vary in severity. Misdemeanors are less serious and felonies are more serious. In a criminal case brought before a court, there is a prosecutor and a defendant. In trials, the government is the prosecutor, representing the victim or society against the defendant. The defendant can be either an individual or a corporation. Proof required for a criminal case must be beyond a reasonable doubt in order to convict a defendant. The result of a criminal case is the punishment and/or loss of liberties, for example, going to jail. Civil law regulates relations between individuals or corporations rather than between a violator and public or government. In civil cases, the plaintiff is seeking compensation or equitable relief. Equitable relief can be an injunction or some order of specific performance. The burden of proof in a civil case is the preponderance of evidence. This burden is significantly less than the more stringent beyond a reasonable doubt. Some people think of the difference as being the need to prove a civil case by 51% and a criminal case by 99.9%. In cases of environmental harms, there can be both civil and criminal penalties. Often the intention to do harm willfully and/or knowingly results in criminal sanctions, increasingly so in more recent years. Many examples of this are found in cases involving waste disposal and water or air toxics pollution. Several constitutional principles underlie the American legal system in general and environmental law specifically, so they are worthy of consideration in this course. The Constitution was written by wealthy men who are arguably more interested in protecting their own interests, including property and/or business ownership. Thus, a major objective in drafting the Constitution was protection of private property. In addition, the framers of the Constitution were heavily influenced by the philosopher John Locke. He asserted that government is a social contract by which people living in a state of nature agreed to form government that would make rules by which all would abide. To prevent this government from being oppressive, individuals, according to Locke, had to retain certain rights. These inalienable rights include the right to the pursuit of life, liberty, and property. The Constitution is considered an embodiment of our social compact. Federalism. The constitutional principle of federalism provides that the authority to govern is divided between two sovereigns or supreme lawmakers. The two sovereigns are the state and the federal governments. The federal government has only those powers granted in the Constitution. Further, any powers not given exclusively to the federal government or taken from the states are reserved to the states. In fact, the Constitution prescribes that the majority of powers are reserved to the states, and thus a central characteristic of federalism is its allocation of power to control local matters to local governments. For those powers prescribed to the federal government, there may be concurrent authority, which means that states may regulate the same subject area. Since there is an inherent chance for conflict under concurrent authority, the Supremacy Clause prescribed in Article 6 of the Constitution provides that any state or local law in conflict with the federal constitution, laws, or treaties is void. An especially important aspect of environmental law is the inclusion of rules established by federal administrative agencies as federal law. Thus, state agencies or legislatures may impose more restrictive environmental laws or regulations, but not less restrictive than those from the federal government. Federal preemption. The Supremacy Clause is also the basis for the doctrine of federal preemption. Under this doctrine, any state that does not directly conflict with federal law, but is in an area of law in which the federal legislation is so pervasive that it is evident Congress intended only federal regulation in that general area, it is said that federal law preempts the field. Instances of federal preemption are especially likely to arise in matters pertaining to interstate commerce, in which a local regulation imposes a substantial burden on the flow of interstate commerce through a particular state. Commerce Clause. Authority of Congress is limited to powers listed in Article 1 of the Constitution. Commerce is the exchange of goods and services. The Commerce Clause within Article 1 gives Congress the authority to regulate commerce with foreign nations and among several states and Indian tribes. Even some activities that are arguably only within one state may be considered interstate if they influence the outcome of interstate commerce. It is important to note that the Commerce Clause is the basis for the power of Congress to pass most environmental statutes. Lawsuits that focus on appropriateness of a federal environmental regulation for a particular activity can center around whether or not the federal government has the authority to regulate the activity based on the Commerce Clause. Thus, at any given time, the makeup of the courts and their predisposition toward interpreting the Commerce Clause might affect the direction of the decision. Specifically, a broad interpretation of the Commerce Clause favors federal power and public interest, while a narrow interpretation of the Commerce Clause favors local power and private interest. Hodel v. Virginia Surface Mining and Reclamation Association Incorporated. The decision for this case serves as an example of the broad interpretation of the Commerce Clause. Congress passed the Surface Mining Control and Reclamation Act of 1977, a statute establishing a number of requirements for strip mining, including a controversial provision that any land used for strip mining be returned to approximately its original state. Mining companies argued that the act was attempting to regulate private land, which is up to the state. The Supreme Court upheld the broad interpretation of the Commerce Clause, i.e., the activity affects interstate commerce, thus it is under federal jurisdiction. In crafting their interpretation, the court reviewed the congressional record and determined that the Congress had held extended hearings concerning the effects of surface mining on the nation's environment and economy and the need for uniform minimum nationwide standards. Thus, Congress had a rational basis for its findings set out in the act itself that surface coal mining has substantial effects on interstate commerce. Solid Waste Agency of Northern Cook County v. U.S. Army Corps of Engineers. Migratory Bird Rule Case, or SWANCC decision. This decision serves as an example of a narrow interpretation of the Commerce Clause. The Army Corps of Engineers is in charge of issuing permits allowing the discharge of dredge or filled material into navigable waters. The Clean Water Act defines navigable waters as water of the United States, and the Corps regulations define such waters to include intrastate waters, the use, degradation, or destruction of which could affect interstate or foreign commerce. In 1986, the Corps attempted to clarify its jurisdiction, stating in what has been dubbed the Migratory Bird Rule that the Clean Water Act extends to intrastate waters that provide habitat for migratory birds. Their reasoning was that migratory birds attract tourism. Tourism is an important form of interstate commerce. Thus, since migratory birds require the use of wetlands that are not directly connected to navigable waters of the United States, federal jurisdiction over wetlands was as a rational extension of the Clean Water Act authority. In this case, the plaintiffs argued against the application of the migratory bird rule in their activity. A consortium of suburban Chicago municipalities wished to create a landfill, and they selected an abandoned sand and gravel pit with excavation trenches for a landfill site. The former pit had evolved into a permanent seasonal pond. Because repurposing of the site as a landfill called for filling in some of the ponds, the petitioner contacted the Army Corps of Engineers to seek a permit. The Corps refused to issue a permit to fill these wetlands. The petitioner challenged the Corps' jurisdiction and the merits of the permit denial. The Supreme Court ruled in favor of the petitioner and against the Army Corps' jurisdiction to regulate the site. The precedent now has implications to restrict the ability of federal agencies to regulate wetlands that have no connection to interstate waterways. Since this 2001 decision, the EPA has called for Congress to clarify jurisdiction over wetlands. Presumably, this would happen via amendments to the Clean Water Act. However, currently, to fill the void left by a lack of legislative clarity, the EPA and the Army Corps of Engineers have proposed rules to clarify which wetlands fall under federal jurisdiction. We will discuss the history and recent developments in interpretation of the Clean Water Act later this semester. The Fourth Amendment. The Bill of Rights is the first 10 amendments in the U.S. Constitution and outlines individual rights that cannot be violated by the federal government. The Fourth Amendment is the protection from unreasonable search and seizure. This protection extended both to individuals and corporations. Unreasonable usually means without a court warrant justified by a probable cause. That is, the suspicion of a violation is probably correct, so the court grants a warrant to search and seize private property. The EPA must secure an administrative warrant to search a business. This sort of warrant requires a neutral enforcement plan and no selective enforcement. The Fifth and 14th Amendment. The Fifth and 14th Amendments both contain due process clause. This states that nobody can be denied a right to life, liberty, or property without the due process of law. The Fifth Amendment holds the federal government accountable, while the 14th Amendment applies to state governments. Due process traditionally refers to a trial, but the procedures that a government must follow in order to take someone's property or liberties are not explicitly clear. The level of deprivation to the individual determines what must be proven and exercised by the government. The Takings Clause. The Fifth Amendment also states that just compensation is required when the federal government takes private property for public use. This concept is also applied to state governments through the Due Process Clause in the 14th Amendment. There is often dispute over whether placing public welfare-based restrictions on the use of property qualifies as a taking, based on decreased value or loss of beneficial use. There are many organizations dedicated to preservation of private property rights. These organizations view requirements imposed by federal regulations on private property owners as a taking. Table 1.6 in your textbook provides examples of these sorts of property rights advocacy groups.